Welcome to Wednesday's Deep Dive. Today I'm talking about 3 cases. These cases relate to Albanian clients, but they relate to issues that go far wider than Albanian cases. The cases themselves are quite complex and some people might find them daunting or impossible. But I'm going to talk about how, with proper representation and proper preparation, one can achieve a good result. Now, the first type of case relates to an individual who'd used deception when obtaining leave to remain. He was on a 10-year visa. That's a 10-year route to indefinite leave to remain. The second case relates to an individual and his family who'd acquired British citizenship by deception. They had wrongly stated that they were born in a different country. The third topic we're going to talk about is asylum appeals and what can be done and what happened in these cases, which meant that the Home Office withdrew the appeal and granted the appellants 5 years leave to remain without them going to court, which is particularly beneficial to the clients because it saves them, particularly if they're vulnerable, from having to give evidence in a court setting. So we have 3 types of cases. All of them, however, involve risk, real risk to individuals, risk of harm if they're returned, risk of being rendered stateless, risk of being subject to removal action in the United Kingdom, risk of losing their nationality. And let's see what happens to each one of them. Now, the first case related to a client of mine who was on the 10-year route to indefinite leave to remain. That meant that he had to renew his visa 4 times before getting to the 10 years. This means that he didn't have indefinite leave to remain, he didn't have settlement, he wasn't a British citizen, his immigration status was precarious. Now, this client came to me and said, I'm really troubled because the information that I provided the Home Office a long time as to where I was born was incorrect. In fact, I provided a lot of other incorrect information and I want to sort this out. What should I do? Now, having considered his case and circumstances surrounding it, we agreed that the best way forward was to tell the truth. It normally is the best policy. In fact, it is always the best policy in respect of immigration. So, with that in mind, we set out the family circumstances, the circumstances that sadly led to him giving the Home Office false information. And having proactively told the Home Office about this, we also set out the reasons why they should vary the details on his grant to leave to remain rather than determining or curtailing his leave. There was quite a lot of work to be done because on the face of it, he had been dishonest. And the Home Office, quite rightly, don't like dishonesty. So he set out his immigration history, he set out his personal circumstances, he set out his family circumstances, his ties to the United Kingdom. And I prepared representations referring to the relevant law. Having made the application to vary the details, we waited a considerable period of time. He was becoming trouble because he needed to travel. So we sent what's called a pre-action letter. We invited, or rather suggested, that the Home Office make a decision promptly, otherwise we would consider judicial review proceeding. The Home Office responded to the pre-action letter and said it would take them 6 months to make a decision. That was on, say, Monday, but by Thursday we received an email saying that they had agreed to our request, that they were prepared to vary his details and not curtail or end his leave to remain. Now, this is a fantastic result for him and for his wider family. What do I take away from this? I take away from it that he volunteered the information. I take away the fact that we prepared everything carefully. We were alive to the issue of dishonesty and the approach the Home Office takes to it, but we set out all the reasons why it would just be inappropriate, disproportionate or unlawful to ask him to leave the country. It took a lot of work, but having set it all out properly, and despite the bit of a delay, I was very pleased that the Home Office looked at it and agreed to our request. So that's fantastic news for him. He and his family can carry on with their lives, they'll be able to travel, and hopefully in due course they'll be able to apply for indefinite leave to remain. In the second type of case I want to talk to you about, the stakes were even higher. In this case, the entire family had been granted British nationality. They then applied for British passports and they travelled on their British passport. I had a conference with the family, they got in touch with me and they disclosed to me that actually the passports were obtained or the nationality was obtained on a false premise. Many years ago, when one of them had entered the United Kingdom, he'd said that he was born in Kosovo and not Albania. And that's to set the ball rolling for further grants of leave to remain, indefinite leave to remain, British citizenship. And the rest of the family have been caught up with all of this. Now, when they came to me, I could see that they were in distress. I've had quite a few clients that are in distress, and we talked it through. And they were quite clear, and I encouraged this, that they should tell the truth to the Home Office. They didn't want to live a lie anymore. It was affecting the quality of their life and their ability to enjoy being in the United Kingdom. I could see that they were deeply troubled. Having sat down with them, having looked at their family circumstances, having looked at the mode of arrival, the age at arrival, and their personal circumstances, we then prepared representations and an application to the Status Review Unit. We were volunteering this, we hadn't been found out. And we explained all of the circumstances. And we explained this by reference to the Home Office's own guidance on nationality, on good character. Now, these are very complicated applications and the decision could go either way. So it was with some enormous relief when I received an email from the Home Office saying that the Status Review Unit were not going to revoke or deprive them of citizenship. The Status Review Unit told me that they were prepared to let matters lie. Previously, the applicants had in the process applied for an amendment to their certificate of naturalisation and had obtained short-term passports in their true identities. Now, they'll be able to apply for proper 10-year passports and carry on with their life. I'm really relieved and pleased for them. As I say, I've had quite a lot of people that turn up and I can see that they are under a huge amount of stress as a result of all of this. So it's a good result and it shows the benefits of not only coming clean, but also preparing the case properly. So this is a fantastic result. The entire family now have properly issued British passports and they are no longer living under the threat of having their nationality stripped off them. It means they can get on with their lives, they can put this matter behind them, and they need never ever contact an immigration lawyer again. The third type of case is somewhat different. This relates to ongoing asylum appeals. Now, I was representing following the Home Office refusal of a couple of asylum applications to appellants. Both of them had quite compelling but quite different cases. We'd lodged the appeal, we'd instructed the various experts, we'd taken the statements. We'd acted promptly in the preparation of the case. Our house was in order. We'd lined our ducks up in the correct row. We then filed all of this with the court. Now, these cases would have, if they'd proceeded to an appeal hearing, presented the appellants with a very challenging day in court. I had no real doubt that the cases were highly meritorious and that they ought to succeed. But one can never tell with litigation. Plus, for vulnerable clients, it can be a challenge going to court. I go quite often, so I'm quite used to it. But for people that are not used to sitting before a judge who could make a decision on the rest of their lives, it must be very scary. And it must be even scarier if the individuals are vulnerable. It was with some pleasure that I discovered that the Home Office, not in one case, but in both cases, having reviewed all of the papers, including the evidence and the legal argument, emailed me to say that they were withdrawing the immigration decision. The effect of that is if the decision is withdrawn, there is no appeal because you can't have an appeal against a non-decision. Furthermore, the email stated that the Home Office, having looked at everything, was prepared to grant them 5 years visa as refugees in the United Kingdom. That is a massive relief to both of them and to their dependents because it means they will not need to go to court. And it means that they will be granted refugee status. It's a huge result, and it shows that what can be done, there's no guarantee of course, what can be done if a case is properly prepared on paper and not just argued very well in court. So a great result all round. So in summary, what do I take away from all of this? Well, the first thing is that good results are often as a result of proper strategic judgment. Second thing is that individuals, if they're faced with a difficult decision, should not panic and they should not hide from problems. As we've seen in the cases with the deceptive identity, they faced up to them. Leading on from that, as you can see in the identity cases, we chose, which is the right thing to do, transparency. We chose to tell the truth, volunteer the information, not run the risk of the Home Office finding out in the future. In the asylum cases, we chose full preparation at the earliest available opportunity, putting the case in the best possible framework before we go to court. Now, some people might prefer to rely on very clever oral argument in court and the witnesses impressing the judge. In my view, that should only happen if the Home Office can't be persuaded on the basis of written evidence to allow an appeal or agree to withdraw their decision. This is what 25 years worth of immigration experience has given me. It's knowing when to fight, when it's not a good idea to fight, and how to avoid the fight, ensuring your clients have the best opportunity of getting what they want. So if you are living in the United Kingdom and there's something wrong with the information you provided the Home Office, if you're facing an asylum decision or you're in the middle of an asylum appeal and you're not quite sure what's happening with the appeal and you're scared of the court hearing, if you're worried about your citizenship being deprived because of something that happened a long time ago, or if you're just stuck with a very complex immigration problem, don't guess, don't put your head under the table, don't bury it in the sand, get proper legal advice. The sooner you get proper legal advice, the sooner, hopefully, you can get some certainty in your life. And if you want independent and expert legal advice or just an opinion on your case, get in touch with me. We can arrange a conference, arrange a discussion, you can come in and see me. I will look at all of the case, the history, and then I will be in a position to advise you as to what is the best course of action for you and your family. If you found this video helpful, please subscribe to my channel. If you've got any comments, I always love reading comments, then leave them below. And I look forward to seeing you in the next video.